Welcome back to Constitutional Corner. The last time we talked, which was episode 2, we finished up Marbury versus Madison, and we discussed Ex parte McCardle. Today, we're going to talk about Section 2. In Section 2, this is still the 11th Amendment, talks about constitutional and judicial limitations. Section 1, Actions Against State of Officials and the 11th Amendment. This is the Charles Allen Wright Federal Courts. This was in 1970. And it goes on to say, in Ex parte Young, 209 U.S. 123-28, Supreme Court 441-52, Legal Edition 714, year 1908. The Minnesota legislature passed a law reducing railroad rates and providing very severe penalties for any railroad which failed to comply. Stockholders of 9 railroads brought suits in federal court to enjoin the companies of which they were stockholders from complying with the law. They alleged that the rates prescribed by the new law were unjust, unreasonable, and confiscatory, and would deprive the companies of their property without due process of law, contrary to the 14th Amendment, but that the penalties under the law were such that railroads, if not restrained, would comply with it. Among other defendants were included Edward T. Young, the Attorney General of Minnesota, and prayed that he be restrained from seeking to enforce the law. This relief was given over Young's objection that the suit was in fact a suit against the state, to which the state had not consented, and thus barred by the 11th Amendment. The Supreme Court did not write on a clean slate in deciding Young's case. In 1793, in the unpopular decision of Grisholm versus Georgia, it had held that the Constitution permitted a citizen of one state to sue another state in federal court, though the state had not consented to such suit. The 11th Amendment was ratified 5 years later to take away the judicial power of the federal courts in such cases, though in terms it does not so provide, it was construed as barring suits against a state without its consent, even where, as in Young's case, the suit was brought by a citizen of the state, and the basis of the jurisdiction was a claim under federal law. In an early decision, Chief Justice Marshall had construed the amendment as barring suit only where the state was formally a party of record. But the principle embodied in the 11th Amendment was too vital to be restrained by such formalism, and Marshall himself later construed the amendment as applying to a suit against the governor of a state where he was being sued in his official capacity. Over the next half-century, the decisions were varying and uncertain. The court undertook to rationalize them and establish a rule on the subject. In 1887, in the case of Henry Ayers, the decision there was that suit against a state officer was not barred where his action, aside from any official authority claimed as its justification, was a wrong simply as an individual act, such as trespass, but that if the act of the officer did not constitute an individual wrong and was something which only the state, through its officers, could do, the suit was in substance a suit against the state. The case would seem to be decisive on the Young litigation. Only a state can violate the 14th Amendment. Only a state can compel railroads to charge particular rates. Indeed, in the Ayers case, the relief unsuccessfully sought was an injunction restraining state attorneys from bringing suits under a supposedly unconstitutional statute. The law was clouded between 1887 and 1908, when the Young's case came to the court, by decisions which, in dicta at least, suggested that the commencement of a suit to enforce an unconstitutional statute could be considered an actionable wrong similar to a trespass. Against this erratic background, the court held that the injunction against Young was proper. Justice Peckham, for the court, announced that the rule which has since been repeatedly followed, quote, the use of the name of the state to enforce an unconstitutional act to the injury of the complaints is a proceeding without the authority of, comma, and which does not affect, comma, the state in its sovereign or governmental capacity. It is simply an illegal act upon the part of the state official. If the act which the state attorney seeks to enforce be a violation of the federal constitution, the officer in proceeding under such an enactment comes into conflict with the superior authority of the Constitution, and he is in that case stripped of his official or representative character and is subject in his person to the consequences of his individual conduct. Only the first Justice Harlan dissented. In a lengthy opinion, he argued, quote, the suit was, as to the defendant Young, one against him as, comma, and one again because he was Attorney General of Minnesota. No relief was sought against him individually, but only in his capacity as Attorney General. And the manifest, indeed, the avowed and admitted object of seeking such relief was to tie the hands of the state, so that it could not in any manner or by any mode of proceeding in its own courts test the validity of the statutes and orders in question. It would therefore seem clear that within the true meaning of the 11th Amendment, the suit brought in the federal court was one in legal effect against the state. There is no doubt that the reality is as Justice Harlan stated it. The fiction has its own illogic. The 14th Amendment runs only to the states. In order to have the right to relief under the amendment, the plaintiff must be able to show that the state action is involved in the denial of his rights. It might have been possible to hold the 14th Amendment qualified the immunity from suit granted states by the 11th Amendment, but the court did not so hold. Instead, it created the anomaly that enforcement of the Minnesota statute is state action for purposes of the 14th Amendment, but merely the individual wrong of Edward T. Young for purposes of the 11th Amendment. Seemed to hold that an action unauthorized by state law could not be state action for purposes of the 14th Amendment. This decision has never been specifically overruled, but it was settled 5 years after Ex parte Young. That action by a state officer claiming to act under authority of the state can be enjoined, even if the state has not authorized such action. The effect of Ex parte Young is to bring within the scope of federal judicial review actions which might otherwise escape such review. If Ex parte Young had been decided the other way, there would have been no practicable means for the railroads to obtain a court determination of the new rates Minnesota wanted them to charge. The state could, of course, consent to suit, either in its own courts or in federal court, simply as a matter of grace, but even today most states have not done so. The railroads could have refused to obey the new law and asserted its unconstitutionality as a defense to an action against them for its enforcement. But the state might have chosen to enforce the law by the criminal sanctions it supplied, and these were so severe that the railroads could not risk the possibility that they might lose and have to pay crushing fines. In some situations, as where a state has failed to desegregate its schools, affirmative action is required of the state to fulfill its constitutional obligations, and there would not be even the possibility of raising the constitutional issue defensively. The decision was greeted with harsh criticism for years thereafter. For half a century, Congress and the court have vied in placing restrictions on the doctrine there announced. Notes and questions. Restrictions on Ex parte Young. Exhaustion of the administrative remedies. In the same year that Young was decided, the court somewhat limited the power of the single federal district court judge to enjoin the enforcement of state statutes by holding that, as a matter of comity and equitable discretion, rather than as a matter of federal jurisdiction, a federal injunction should not issue until the allegedly aggrieved party has exhausted all adequate state administrative remedies. See Prentice v. Atlantis Coastline, 211 U.S. 210, 29 Supreme Court 6753 LED 150. Good Lord. B, and it goes on to say A, that was A. This is B. 3 judge courts. In response to Young, Congress, beginning in 1910, enacted statutes providing that no federal injunction restraining a state officer from enforcing a state statute or administrative order on grounds of unconstitutionality shall be issued except by the court of 3 judges, at least one of whom is a circuit judge with direct appeal to the Supreme Court. See 28 U.S.C.A. section 2281 and 2284. Sorry about all that. I needed a drink of water, needed a break. Then it goes on to talking about case or controversy, section 2 of, or subsection 2 of section 2. Then it goes on and says advisory opinions. In 1902, in Muskrat versus United States, which is 219 U.S. 346 31, Supreme Court 250, 55 LED 246 1911. In 1902, Congress made a final allotment of lands to certain Cherokee Indians. Subsequent legislation increased the number of allottees and imposed various restrictions. Congress then enacted a statute authorizing 4 named allottees under the 1902 Act to bring suits against the United States in the Court of Claims with appeal to the Supreme Court. Quote, on their own behalf and on behalf of all other Cherokee citizens, end quote, who were allottees under the 1902 Act, begin new quote, who were allottees to determine the validity of any acts of Congress passed since the said act. For the speedy disposition of the questions involved, such suits were to be given preference by the courts, and attorneys' fees were to be paid out of tribal funds held by the government if the subsequent legislation were held invalid. Suits were instituted, and the courts of claims sustained the validity of the subsequent legislation. The court, per Justice Day, held that the jurisdiction conferred was not within the power of Congress, having in view the limitations of the judicial power as established by the Constitution, because the judicial power is limited to cases and controversies. Article 3 does not extend the judicial power to every violation of the Constitution, which may possibly take place. By cases and controversies are intended the claims of litigants brought before the courts for determination by such regular proceedings as are established by law or custom for the protection and or enforcement of rights, or the prevention, redress, or punishment of wrongs. The term implies that the existence of present or possible adverse parties whose contentions are submitted to the court of adjudication. The court pointed out that as early as 1792, an act of Congress authorized federal courts to decide certain pension claims against the government, subject to revision by the Secretary of War. In Hayburn's case, 2-409, the court held that such duties were beyond the judicial power. By the Constitution, neither the Secretary at War nor any other executive officer, nor even the legislature, are authorized to sit as a court of errors on the judicial acts or opinions of the court. In 1793, the court, in response to request by President George Washington and Secretary of State Jefferson, declined to offer its advice on the construction of treaties, laws of nations, and laws of the land, which the Secretary said were often presented under circumstances which do not give any cognizance of them to the tribunals of the country. To act in Muskrat was found to be nothing more than to an attempt to provide for a judicial determination, final in this court, of the constitutional validity of an act of Congress. It is true, the United States is made a defendant to this action, but it has no interest adverse to the claimants. The object is not to assert a property right as against the government, or to demand compensation for alleged wrongs because of an action upon its part, The judgment will not conclude private parties. When actual litigation brings to the court the question of the constitutionality of such a legislation. In a legal sense, the judgment could not be executed, and amounts in effect to no more than an expression of opinion upon the validity of the 1902 Act. If such actions were, as are here attempted, are sustained, the result will be that this court, instead of keeping within the limits of judicial power and deciding cases or controversies arising between opposing parties, as the Constitution intended it should, will be required to give opinions in the nature of advice concerning legislative action, a function never conferred upon it by the Constitution. Notes and questions. Pros and cons of advisory opinions. So basically, like, let's say the president went to the court and said, I'm thinking about doing this legal action. Is it legal? He can't do that. In fact, he can try. But what's going to happen is the Supreme Court's going to say that's an advisory opinion, President. You're on your own. Do you agree with the well-established principle that bars the court from advising the Congress on the constitutionality of legislation? Consider note advisory opinions on the constitutionality of statutes. Harvard Law Review 1302, which says, before it is successfully challenged, an unconstitutional statute may discourage legitimate activity, or conversely, it may encourage reliance, which, when the state is invalidated, will prove to have been ill-founded, thus causing injury to those who have based action upon it. Further, there is frequently an unnecessary expenditure of time and money when the state enacts a statute, invalidates it in lengthy judicial proceedings, and subsequently must enact new legislation. This waste would seem particularly great when the government sets up elaborate machinery to implement a statute later held unconstitutional. Makes sense. Consider the comment from the advisory opinion and United States Supreme Court for Law Review. It says, the advisory opinion, it is said, by Frankfurter, the advisory opinion, as it said, would distort the entire focus of the judicial function in that it would require the court to express its judgment on abortive issues without the benefit of all of the relevant facts, which, in crucial constitutional questions, are the very heart of the case. In addition, the operation of the device would debilitate the creative responsibility of the legislature in that it would tend to induce reliance upon the judiciary, depriving the former of submitting its convictions to the test of trial and error and of accumulating new facts for the vindication of its judgment, which a priori may run counter to settled legal principles. As to the facts argument, might this be cured by having Congress present the court with a specific set of facts, real or assumed, or by having the court confine its opinion to the statute's application to what it considers to be most common set of facts intended to be covered? As to the responsibility of the legislature's argument, might this be cured by limiting the advisory opinions to statutes fully considered and already passed by Congress? Is there any answer to the point that the cumulative experience of the statute's operation may shed great light on its constitutionality? If not, is this point sufficient to sustain the present advisory opinion practice? C. Is the opposition to advisory opinions justified by the fact that only when the experienced judge has had the benefit of intelligent and vigorous advocacy on both sides can he feel fully confident of his decision? Could the court, before rendering an advisory opinion, invite the submission of briefs and presentation of argument by interested parties on both sides of the question? Argument in advisory proceedings might in some situations provide more assistance to the court than would argument in a normal adversary proceeding. Representation of diversified interests might provide the justices with a more realistic perspective on the statute than representation of only the two parties. And unlike ordinary litigation where the prosecutor or plaintiff may be able to select an opponent with little interest in the proceeding, or one who is peculiarly culpable, the parties seeking to appear will generally be strong antagonists. See also Arnold Trial by Combat and the New Deal, Harvard Law Review 913, 1934. And it goes on to say, consider note, judicial determinations in a non-advisory proceedings. The requirement that a specific injury have been suffered or that the danger of such injury be substantial probably has its basis, at least partially, in the belief that the respect in which the courts are held varies with the restrained exercise in deciding only the most critical questions. Is this belief founded on the premise that the court's ability to preserve constitutional values is limited and should be reserved for situations in which it is absolutely necessary? If so, may occasions for some advisory opinions present such a necessity? Or should the enactments of popularly elected representatives be invalidated by a court of lifetime appointees only when the injury is imminent? Even when the popularly elected representatives request the court's advice, even when they believe that the withholding of such advice may provide very grave injuries. The next section is mootness and conclusiveness. And again, this is the Charles Allen Wright Federal Courts, 1970. Moot cases are held to be beyond the judicial power. There is no case or controversy once the matter has been resolved. The court has had particular difficulty in determining whether a criminal case is moot after the defendant has served his sentence and been released. The court first held that such a case is moot, but after a great deal of backing and filling, has come to acknowledge the obvious fact of life that most criminal convictions do in fact entail adverse collateral legal consequences. The mere possibility that this will be the case is enough to preserve a criminal case from ending ignominiously in the limbo of mootness. In rare instances, the power to refrain from deciding moot cases has been used by the court to avoid decision of an otherwise difficult matter. In one such case, challenge was to the validity of the state statute regulating the labor of use between ages of 14 and 16. The court held that the case for 2.5 years after argument, and then decided that, since the plaintiff was by that time over 16 and no longer affected by the statute, the case was moot. It is held also that the courts will not hear collusive cases. Though the rule is not in terms so confined, it is principally applied in constitutional cases, on the notion that it never was the thought that, by means of a friendly suit, a party beaten in the legislature could transfer to the courts as inquiry as to the constitutionality of the legislative act. Even here, application of the rule has not always been rigid. Some of the most famous constitutional decisions have come in what now seem to have been collusive cases. The rule against collusive litigation does not mean, though it is sometimes stated as it is meant, that the parties must actually disagree. A court has jurisdiction to render judgment by default or on plea of guilty. But if one party is financing and controlling both sides of the litigation, the court should deem the suit collusive. Notes and questions on mootness and conclusiveness. The rationale for the rationale for the ban on moot cases. Do you agree that moot cases are beyond the judicial power? Or is this merely a judicially created rule for judicial economy? If a case presenting important and far-reaching constitutional questions becomes moot as to the immediate parties involved, should the court be constitutionally restrained from deciding it? Suppose the parties have argued that the case before it became moot. Does this question merely restate the advisory opinion problem? Consider note, cases moot on appeal, a limit of the judicial power, University of Pennsylvania Law Review. It says, moot cases do not present all the dangers of advisory opinions. The impact of actuality may well be lacking if the decree cannot affect the rights of the parties. Or decree, not degree. Decree. But there is a record to which the court may look for facts. There is probably as much experience under the statute as might be had in a case which is not moot, and there are advocates before the court who are prepared to argue the issues. For discussion of a trend in the court to complete abolition of the mootness doctrine in order to set our guidelines for the future, see Singer, Justiciability, and recent Supreme Court cases. That was another law review from Alabama. And then the book on page 39. Let's take a water break real quick. All right. Sorry. Sorry about that. Standing in ripeness. Introductory note. The two broad issues to be considered in this section are further aspects of the concepts of justiciability and case or controversy. The questions they raise go to determining whether there is a dispute capable of and suitable for judicial resolution. These two issues frequently overlap, but may generally be described as concerning one, who may assert certain contentions, the claimant or someone else, standing, and two, when, if ever, may the claims be asserted, now or at some subsequent time after other events have occurred, ripeness. Limitations derived from both Article 3. Sorry, my sinuses are going crazy. Limitations derived from both Article 3 and principles of self-restraint arise, and some perspective in regard to the latter may be found in the following statement of the Court for Justice Rutledge in Rescue Army versus Municipal Court 331 U.S. 549, 67, Supreme Court 1409, 91, L. Ed. 1666, 1947. And it said, and that court said, this court has followed a policy of strict necessity in disposing of constitutional issues, which has not been limited to jurisdictional determinations. For in addition, the court has developed, for its own governance in the cases confessedly within its jurisdiction, a series of rules under which it has avoided passing upon a large part of all constitutional questions pressed upon it for decision. My mouth. Thus, as those rules were listed in support of the statement quoted, constitutional issues affecting legislation will not be determined in friendly, non-adversarial proceedings in advance of the necessity of deciding them in broader terms than are required by the precise facts to which the ruling is to be applied. If the record presents some other ground upon which the case may be disposed of, at that instance of one who fails to show that he is injured by the statute's operation, or who has availed himself of its benefits. Every application has been an instance of reluctance, indeed of refusal, to undertake the most important and most delicate of the court's functions, notwithstanding conceded jurisdiction, until necessity compels it in the performance of constitutional duty. Indeed, in origin and in practice effects, though not in technical function, it is a corollary offshoot of the case and controversy rule, and often the line between applying the policy or the rule is very thin. The policy's ultimate foundations, some if not all, which also sustain the jurisdictional limitation, are found in the delicacy of the function, particularly in view of possible consequences for others stemming also from constitutional roots, the comparative finality of those consequences, the disconsideration due to the judgment of other repositories of constitutional power concerning the scope of their authority, the necessity, if government is to function constitutionally, for each to keep within its power, including the courts, the inherent limitations of the judicial process, arising especially from its largely negative character and limited resources of enforcement, withal in the paramount importance of constitutional adjudication in our system. We'll take a water break. Hold on. I do want to apologize. My sinuses have been going crazy the last couple days. This heat's really, really getting to me. Anyway, I'm going to try to finish these next 50 pages. Let's try. Okay. Its execution has involved a continuous choice between the obvious advantages it produces and the very real disadvantages for the assurances of rights, which deferring decision very often entails. On the other hand, it is not altogether speculative that a contrary policy of accelerated decision might do equal or greater harm for the security of private rights. For premature and relative abstraction decisions, which such a policy would be most likely to promote, have their part too in rendering rights uncertain and insecure. Quote, as with the case in controversy limitation, however, the choice has been made long since. Time and experience have given it sanction. They have also verified for both that the choice was wisely made. Any other indeed might have put an end to or seriously impaired the distinctively American institution of judicial review. And I agree. I think that's right. I think that putting limitations on what they can try, number one, it doesn't bog them down, so they can thoughtfully decide things. At least we hope they do. And you'll see, not always. In this book, you'll notice there's a lot of back and forth between principles. Sometimes the people win, sometimes people don't win. There's many cases in this big book, and we're gonna go through it all eventually. Like I said, there's about, let's see, this book that I'm reading from has 1,074 pages, and we're at page 41. So we've got a long way to go on this. A lot of episodes, but for now, we're just talking about standing in ripeness. Limitations on judicial review. It goes on to page 41 and talks about Massachusetts versus Mellon. This is a new case. And it's actually two cases. It's Massachusetts versus Mellon and Frothingham versus Mellon. That case number is 262 US 447, 43, Supreme Court 597, 67, LED 1078, 1923. These were both suits challenging a federal statute that provided funds to those states undertaking programs to reduce maternal and infant mortality. A unanimous court, per Justice Sutherland, disposed of both cases for want of jurisdiction. Massachusetts contended that the act was beyond congressional power and invaded the, quote, the power of local self-government reserved to the states by the 10th Amendment, that a state had an unconstitutional option either to yield to the federal government a part of their reserved rights or to lose their share of the monies appropriated. Probably it would be sufficient to point out that the powers of the state are not invaded, since the statute imposes no obligation but simply extends an option which the state is free to accept or reject. But we do not rest here. The court's power under Article 3 extends only to proceedings of justiciability character. In the last analysis, the complaint of the plaintiff state is brought to the naked contention that Congress has usurped the reserved powers of the several states by the mere enactment of the statute. Though nothing has been done and nothing is to be done without their consent, it is plain that the question, as it is thus presented, is political and not judicial in character. And the exercise of judicial power. And therefore is not a matter which admits of the exercise of the judicial power. We are called upon to adjudicate not rights of person or property, not rights of dominion over physical domain, not quasi-sovereign rights actually invaded or threatened, but abstract questions of political power, of sovereignty, or of government. Because citizens of the Massachusetts are also citizens of the United States, neither could the state sue as parens patriae as the representatives of its citizens to protect the citizens of the United States from the operation of statutes thereof. It is the United States and not the state which represents them as parens patria. It's Latin. Parens patria. And to the former and not to the latter, they must look for such protected measures. And by the way, that for anyone that wants to know how that's spelled, that is PARENS PATRIAE. That's parens patriae, and I think I'm spelling that wrong. Any Latin linguistics out there that could correct me, that would be great. I'm a language lover, so I would not get offended if you corrected me, because I'm actively learning languages. I'm a man of all trades. Anyway, it goes on to say Frothingham, a federal taxpayer, also contended that the Maternity Act exceeded Congress power, and that the effect of the appropriations complained of will be to increase the burden of future taxation and thereby take her property without due process of law. The court distinguished suits by municipal taxpayers. The interest of the taxpayer of a municipality in the application of its monies is direct and immediate, and the remedy by injunction to prevent their misuse is not inappropriate. But a federal taxpayer's interest in the monies of the Treasury, partly realized from taxation and partly from other sources, is shared with millions of others, is comparatively minute and indeterminable, and the effect upon future taxation of any payment out of the funds so remote, fluctuating, and uncertain, that no basis is afforded for the appeal to the preventative powers of a court of equity. To permit such suits might result in a tax on, quote, every other appropriation act and statute whose administration requires the outlay of public money. The bare suggestion of such a result, with its attendant inconveniences, goes far to sustain the conclusion which we have reached, that a suit of this character cannot be maintained. A person asking the court to hold a federal act unconstitutional must be able to show not only that the statute is invalid, but that he has sustained or is immediate in danger of sustaining some direct injury as the result of its enforcement, and not merely that he suffers in some indefinite way in common with people generally. Here, the complaint is merely that officials of the executive department of the government are executing and will execute an act of Congress asserted to be unconstitutional, and this we are asked to prevent. To do so would be not to decide a judicial controversy, but to assume a position of authority over the governmental acts of another co-equal department, an authority which plainly we do not possess. And then it goes on and says for Doremus versus the Board of Education in 1952, that court number is 342 U.S. 429-72, Supreme Court 394-96 LED 474 or 475. My bad. And this was a suit initiated in state court challenging Bible reading in the public schools as violative of the First Amendment. Oh, here we go. Religion in schools was a suit initiated in state court challenging Bible reading in the public schools as violative of the First Amendment's bar on establishment of religion. The New Jersey Supreme Court, in spite of jurisdictional doubts, rejected the claim on the merits. Applicants had sued as citizens and taxpayers. One had a child in the public school who had graduated by the time the case was appealed to the Supreme Court. So we got a problem of mootness here. They've already graduated from the school. The court, per Justice Jackson, dismissed the appeal. As to the graduated student, no decision we could render now would protect any rights she may once have had, and this court does not sit to decide arguments after events have put them to rest. Although municipal taxpayers have standing to enjoin a measurable appropriation of or disbursement of municipal funds occasioned solely by the activities complained of, there is no allegation that the activity is supported by any separate tax or paid from any particular appropriation, or that it adds any sum whatever to the cost of conducting the school. Although the state courts may render advisory opinions on federal constitutional questions, because our own jurisdiction is cast in terms of case or controversy, we cannot accept as the basis for review, nor as the basis for conclusive disposition of any issue of federal law without review, any procedure which does not constitute such. The taxpayer's action can meet this test, but only when it is a good faith pocketbook action. If appellants establish the requisite special injury necessary to a taxpayer's case or controversy, it would not matter that their dominant inducement to action was more religious than mercenary. It is not a question of motivation, but of possession of the requisite financial interest, that is, or is threatened to be, injured by the unconstitutional conduct. So, because that student had graduated, they said, sorry, we got to dismiss. And I mean, well, why would they? It makes it kind of like, but in the same breath, I'm kind of glad they're not zealous. That they say, well, it's moot. We can't really decide on this. So that is Doremus versus the Board of Education. And then it goes on to talk about Flast versus Cohen. And that was in 1968, the Chief Justice Warren's court. That number is 392 U.S. 83, 88 SCT Supreme Court, 1942-20 LED 2nd edition 947. And, of course, Mr. Chief Justice Warren delivered the opinion of the court. And he decided uniformly throughout the country. All right. And he says, I disagree with Dormia's case insofar as it lets the state judgment stand and merely declines review. It seems to me that the court should have held that the petition should stand dismissed in the state court and decree vacated so that it would not be a precedent even in the state court. Does Dormius let the state judgment stand and merely decline review? It seems to me the court should have held that the petition should stand dismissed in the state court and the decree vacated so that it would not be a precedent in the state court. Does Dormius let the state judgment stand? What action would the court have taken if the New Jersey court had found the statute violative of the First Amendment? What action should the court take if a state court refuses to entertain a taxpayer suit involving pocketbook injury, challenging a state statute on federal constitutional grounds? As federal taxpayers, appellants sought to enjoin federal expenditures under the Elementary and Secondary Education Act of 1965 to finance institution, textbooks, and other institutional materials in periodical schools, alleging that they were in violation of the Establishment and Free Exercise Clause of the First Amendment by reason of the fact that they were constitute compulsory taxation for religious purposes. A 3-judge federal district court 2-1 that under Frothingham versus Mellon appellants lacked standing. Although the barrier Frothingham erected against federal taxpayer suits has never been breached, the decision has been the source of some confusion and the object of considerable criticism. The confusion has developed as commentators have tried to determine whether Frothingham established a constitutional bar to taxpayer suits or whether the court was simply imposing a rule of self-restraint. The opinion delivered in Frothingham can be read to support either position. To the extent that Frothingham has been viewed as resting on policy considerations, it has been criticized as depending on assumptions not consistent with modern conditions. For example, some commentators have pointed out that a number of corporate taxpayers today have a federal tax liability running into hundreds of millions of dollars, and such taxpayers have a far greater monetary stake in the federal treasury than they do in any municipal treasury. To some degree, the fear expressed in Frothingham that allowing one taxpayer to sue would inundate the federal courts with countless similar suits has been mitigated by the ready availability of the devices of class actions and joinder under the federal rules of civil procedure. adopted subsequent to the decision in Frothingham. The jurisdiction of federal courts is defined and limited by Article 3 of the Constitution. Embodied in the words cases and controversies are two complementary but somewhat different limitations. In part, those words limit the business of federal courts to questions presented in an adversary context and in a form historically viewed as capable of resolution through the judicial process. And in part, those words define the role assigned to the judiciary in a tripartite allocation of power to assure that the federal courts will not intrude into areas committed to the other branches of government. Justiciability is the term of art employed to give expression to this dual limitation placed upon federal courts. It is in this context that the standing question presented by this case must be viewed. The government's position is that the constitutional scheme of separation of powers and the deference owned by the federal judiciary to the other two branches of government within that scheme presents an absolute bar to taxpayer suits challenging the validity of federal spending programs. The government views such suits as involving no more than mere disagreement by the taxpayer, quote, with the uses to which the tax money is put. According to the government, the resolution of such disagreements is committed to the other branches of the federal government. Standing is an aspect of justiciability, and as such, the problem of standing is surrounded by the same complexities and vagaries that inherit in justiciability. In addition, there are at work in the standing doctrine the many subtle pressures which tend to cause policy considerations to blend into constitutional limitations. The fundamental aspect of standing is that it focuses on the party seeking to get his complaint before the federal court and not on the issues he wishes to have adjudicated. The gist of the question of standing is whether the party seeking relief has alleged such personal stake in the outcome of the controversy as to assure the concrete adverseness which sharpens the presentation of issues upon which the court so largely depends for illumination of difficult constitutional questions. In Baker v. Carr, in other words, when standing is placed in issue in a case, the question is whether the person whose standing is challenged is a proper party to a request and adjudication of a particular issue, and not whether the issue itself is justiciable. Thus, a party may have standing in a particular case, but the federal courts may nevertheless decline to pass on the merits of the case because, for example, it presents a political question. So stated, the standing requirement is closely related to, although more generally than, the rule that federal courts will not entertain friendly suits or those which are feigned or collusive in nature. The question whether a particular person is a proper party to maintain the action does not by its own force raise separation of powers problems related to improper judicial interference in areas committed to the other branches of federal government. Such problems arise, if at all, only from the substantive issues the individual seeks to have adjudicated. Thus, in terms of Article 3 and limitations on federal court jurisdiction, the question of standing is related only to whether the dispute sought to be adjudicated will be presented in an adversary context and in a form historically viewed as capable of judicial resolution. A taxpayer may or may not have the requisite personal stake in the outcome, depending upon the circumstances of a particular case. Therefore, we find no absolute bar in Article 3 to suits by federal taxpayers challenging allegedly unconstitutional federal taxing and spending programs. We have noted that, in deciding the question of standing, it is not relevant that the substantive issues in the litigation might be non-justiciable. Good Lord. However, our decisions establish that in ruling On standing, it is both appropriate and necessary to look to the substantive issues for another purpose, namely to determine whether there is a logical nexus between the status asserted and the claim sought to be adjudicated. To assure that the litigant is a proper and appropriate party to invoke federal judicial power. Thus, our point of reference in the case is the standing of individuals who assert only the status of federal taxpayers and who challenge the constitutionality of a federal spending program. Whether such individuals have standing to maintain that form of action turns on whether they can demonstrate the necessary stake as taxpayers in the outcome of the litigation to satisfy Article 3 requirements. The nexus demanded of federal taxpayers has two aspects to it. First, the taxpayer must establish a logical link between the status and the type of legislative enactment attacked. Thus, a taxpayer will be a proper party to allege the unconstitutionality only of exercises of congressional power under the Taxing and Expending Clause of Article 1, Section 8 of the Constitution. It will not be sufficient to allege an incidental expenditure of tax funds in the administration of an essentially regulatory statute. This requirement is consistent with the limitation imposed upon state taxpayers standing in federal courts in dormias. Secondly, the taxpayer must establish a nexus between the status and the precise nature of the constitutional infringement alleged. Under this requirement, the taxpayer must show that the challenged enactment exceeds specific constitutional limitations imposed upon the exercise of congressional taxing and spending power, and not simply that the enactment is generally beyond the powers delegated to Congress by Article 1, Section 8. The taxpayers' appellants in this case have satisfied both nexuses. Their constitutional challenge is made to an exercise by Congress of its power under Article 1, Section 8 to spend for the general welfare, and the challenge program involves a substantial expenditure of federal tax funds. In addition, appellants have alleged that the established expenditures violate the Establishment of Free Exercise Clause of the First Amendment. Our history vividly illustrates that one of the specific evils feared by those who had drafted the Establishment Clause and fought for its adoption was the taxing and spending power would be used to favor one religion over another to support religion in general, and that religious liberty ultimately would be the victim. That clause of the First Amendment operates as a specific constitutional limitation upon the exercise by Congress of the taxing and spending power conferred by Article 1, Section 8. Frothingham, and you know what? I'm going to go back over that again. This is an official judicial opinion. That clause of the First Amendment operates as a specific constitutional limitation upon the exercise by Congress of the taxing and spending power conferred by Article 1, Section 8. Frothingham is consistent with the test of taxpayer standing announced today. The taxpayer in Frothingham attacked a federal spending program, and she therefore established the first nexus required. However, she alleged essentially that Congress, by enacting the challenged statute, had exceeded the general powers delegated to it by Article 1, Section 8, and that Congress had thereby invaded the legislative province reserved to the states by the 10th Amendment. To be sure, Mrs. Frothingham made the additional allegation that her tax liability would be increased as a result of the alleged unconstitutional enactment, and she framed the allegation in terms of deprivation of property without due process of law. However, the Due Process Clause of the Fifth Amendment does not protect taxpayers against increases in tax liability, and the taxpayer in Frothingham failed to make any additional claim that the harm she alleged resulted from a breach by Congress of the specific constitutional limitations imposed upon an exercise of taxing and spending power. In essence, Mrs. Frothingham was attempting to assert the state's interest in their legislative prerogatives and not a federal taxpayer's interest in being free of taxing and spending in contravention of a specific constitutional limitation imposed upon Congress's taxing and spending power. We have noted that the Establishment Clause of the First Amendment does specifically limit the taxing and spending power conferred by Article 1, Section 8. Whether the Constitution contains other specific limitations can be determined only in the context of future cases. However, whenever such specific limitations are found, we believe a taxpayer will have a clear stake as a taxpayer in assuring that they are not breached by Congress. The taxpayer's allegation in such cases would be that his tax money is being extracted and spent in violation of specific constitutional protections against such abuses of legislative power. Such an injury is appropriate for judicial right redress, and the taxpayer has established the necessary nexus between his status and the nature of the allegedly unconstitutional action to support his claim of standing to secure judicial review. Under such circumstances, we feel confident that the questions will be framed with the necessary specificity, that the issues will be contested with the necessary adverseness, and that the litigation will be pursued with the necessary vigor to assure that the constitutionality challenge will be made in a form traditionally thought to be capable of judicial resolution. We lack the confidence in cases such as Frothingham, where a taxpayer seeks to employ a federal court as a forum in which to air his generalized grievances about the conduct of government or the allocation of the power in the federal system. Reversed. And I'm going to take a short break, and we're going to get to the dissent, because Mr. Justice Douglas concurred. Or not dissent, concurred. There's several concurrences that we're going to talk about, but I'm going to take a short break. Welcome back. Sorry, but thank you for your patience. So, Justice Douglas, concurring, said, "While I have joined the opinion of the court, I do not think that the test it lays down is a durable one for the reasons stated by my brother Harlan. I think, therefore, that it will suffer erosion and in time result in the demise of Frothingham versus Mellon. It would therefore be the part of wisdom, as I see the problem, to be rid of Frothingham here and now. When the court used substantive due process to determine the wisdom of reasonableness of legislation, it was indeed transforming itself into a court of revision, which was rejected by the Constitutional Convention. It was that judicial attitude, not the theory of standing to issue rejected in Frothingham, that involved important hazards for the continued effectiveness of the federal judiciary. To borrow a phrase from my brother Harlan, a contemporary result in Frothingham, in that setting, might well have actuated an ominous trend to judicial supremacy. But we no longer undertake to exercise that kind of power. Today's problem is in a different setting. Most laws passed by Congress do not contain even a ghost of a constitutional question. The case or controversy requirement comes into play only when the federal government does something that affects a person's life, his liberty, or his property. The wrong may be slight, or it may be grievous. Madison, in denouncing state support of churches, said the principle was violated when even 3 pence was appropriated to that cause by the government. It therefore does not do to talk about taxpayers' interests as infinitesimal. The restraint on liberty may be fleeting and passing, and still violate a fundamental constitutional guarantee. The states have experimented with taxpayer suits, and with only 2 exceptions now allow them. A few state decisions are frankly based on the theory that a taxpayer is a private attorney general seeking to vindicate the public interest. Some of them require that the taxpayer have more than an infinitesimal financial stake in the problem. At the federal level, Congress can, of course, define broad categories of aggrieved persons who have standing to litigate cases or controversies. But contrary to what my brother Harlan suggests, the failure of Congress to act has not barred this court from allowing standing to sue and from providing remedies. The multitude of cases under the 4th as well as 14th Amendment are witness enough. The constitutional guide is cases or controversies. There is judicial power to act. There is judicial power to deal with all the facets of the old issue of standing. Taxpayers can be vigilant. Private attorney generals. Their stake in the outcome of litigation may be de minimis by financial standards, yet very great when measured by a particular constitutional mandate. My brother Harlan's opinion reflects the British, not the American tradition of constitutionalism. We have a written constitution, and it is full of thou not shall nots, directly at Congress and the President as well as at the courts. There has long been a school of thought here that less the judiciary does, the better. It is often said that the judicial intrusion should be infrequent, since it is always attended with a serious evil, namely, that the correction of legislative mistakes comes from the outside, and that people thus lose their political experience, and the moral education and stimulus that come from fighting the question out in the ordinary way and correcting their own errors, that the effect of the participation by the judiciary in these processes is, quote, to dwarf the political capacity of the people and to deaden its sense of moral responsibility. Thayer, John Marshall, 1901. The late Edmund Can, who opposed that view, stated my philosophy. He emphasized the importance of the role that federal judiciary was designed to play in guarding basic rights against majoritarian control. The judiciary is an indispensable part of that operation of our federal system. With the growing complexities of government, it is often the one and only place where effective relief can be obtained. If the judiciary were to become a super legislative group sitting in judgment of the affairs of people, the situation would be intolerable. But where wrongs to individuals are done by violation of specific guarantees, it is an abdication for courts to close their doors. The Constitution, even with the judicial gloss it has acquired, plainly is not adequate to protect the individual against the growing bureaucracy in the legislative and executive branches. The individual is almost certain to be plowed under unless he has a well-organized, active political group to speak for him. I would not be niggardly, therefore, in giving private attorneys general standing to sue. I would certainly not wait for Congress to give its blessing to our deciding cases clearly within our Article 3 jurisdiction. To wait for a sign from Congress is to allow important constitutional questions to go undecided and personal liberty unprotected. There need be no indonation of the federal courts if taxpayer suits are allowed. There is a wise judicial discretion that usually can distinguish between the frivolous question and the substantial question. There are numerous subterfuges at work at the federal level in respect to aid to religion. The efforts made to insert in law an express provision which would allow federal aid to secretary and schools to be reviewable in the courts was defeated. I would be as liberal in allowing taxpayers standing to object to those violations of the First Amendment as I would in granting standing of people to complain of an invasion of their rights under any other guarantee in the Constitution itself or in the Bill of Rights. And then Mr. Justice Stewart concurs and says, I join the judgment and opinion of the court, which I understand to hold only that a federal taxpayer has standing to assert that a specific expenditure of federal funds violates the Establishment Clause of the First Amendment, because that clause plainly prohibits taxing and spending in aid of religion. In aid of religion. Every taxpayer can claim a personal constitutional right not to be taxed for the support of a religious institution. The present case is thus readily distinguishable from Frothingham versus Mellon. Let me reread that. We may be a country founded on Christian morals. However, the courts have seen, because that clause plainly prohibits taxing and spending in the aid of religion, Every taxpayer can claim a personal constitutional right not to be taxed for the support of a religious institution. The present case is thus readily distinguishable from Frothingham versus Mellon, where the taxpayer relied not on an explicit constitutional prohibition, but it questioned instead the scope of the powers delegated to the national legislature by Article 1 of the Constitution. And then Mr. Justice Fortas concurs again. Another justice concurs, Mr. Fortas. And he says, I would confine the ruling in this case to be the proposition that a taxpayer maintain a suit to challenge the validity of a federal expenditure on the ground that the expenditure violates the Establishment Clause. As the court's opinion recites, there is enough in the constitutional history of the Establishment Clause to support the thesis that this clause includes a specific prohibition upon the use of the power to tax to support an establishment of religion. There is no reason to suggest, and no basis in the logic of this decision for implying, that there may be other types of congressional expenditures which may be attacked by a litigant solely on the basis of his status as a taxpayer. Perhaps the vital interest of a citizen in the Establishment issue, without reference to his taxpayer status, would be acceptable as a basis for his challenge. We need not decide this, but certainly, I believe, we must recognize that our principle of judicial scrutiny of legislative acts, which raise important constitutional questions, requires the same issue here presented. The separation of state and church, which the Founding Fathers regarded as fundamental to our constitutional system, should be subjected to judicial testing. Let me reread that. I believe we must recognize that our principle of judicial scrutiny of legislative acts, which raise important constitutional questions, requires that the issue here presented, the separation of state and church, which the Founding Fathers regarded as fundamental to our constitutional system, should be subjected to judicial testing. It's another judge concurring with the Establishment Clause, not establishing a religion. So, like I said, we may be founded on religious, or moral, I should say, the ethical and moral teachings of Christianity. That may be the case, but we are not a Christian nation. Our government is not Catholic or Methodist, or that's what I mean by a Christian nation. Our government is neutral. We the people have a religion. That's where the confusion is. We the people have the religion, and that's fine. But when the government starts establishing a religion, that's where it becomes a problem. That's unconstitutional. Get it straight. One moment, please. Sorry about that short delay again. When I went on my tirade, I forgot where I was. But it's true though. Like, I mean, the Establishment Clause prohibits the federal government from establishing the U.S. government cannot say we are a Catholic nation. This government's Catholic. You can't do that. That's an establishment. Anyway, where was I? Perhaps the vital interest of a citizen in the establishment issue, without reference. On the other hand, the urgent necessities of this case and the precarious opening through which we find our way to confront it do not demand that we open the door to general assault upon exercises of the spending power. And then Justice Harlan, he dissents. He's the last justice. He dissents. He disagrees with the court. He says, it could hardly be disputed that the federal taxpayer may, as taxpayers, contest the constitutionality of a tax obligation imposed severally upon them by federal statute. Such a challenge may be made by way of defense to an action by the United States to recover the amount of challenged tax debt. McCrae versus United States versus Butler. Or to pay a prosecution for willful failure to pay or to report to the tax. Moreover, such a challenge may provide the basis of an action by a taxpayer to obtain the refund of a previous tax payment. The lawsuits here and in front of them are fundamentally different. They present the question whether federal taxpayers, qua taxpayers may, in suits in which they do not contest the validity of their previous or existing tax obligations, challenge the constitutionality of the uses for which Congress has authorized the expenditure of public funds. An action brought to contest the validity of the tax liabilities assessed to the plaintiff is designed to vindicate interests that are personal and proprietary. The wrongs alleged and the relief sought by such a plaintiff are unmistakably private. Only secondary are his interests representative of those of the general population. The complainant in this case, unlike that in Frothingham, contains no allegation that the contested expenditures will in any fashion affect the amount of any of these taxpayers' own existent or foreseeable tax obligations. Even in cases in which such an allegation is made, the suit cannot result in an adjudication either of the plaintiff's tax liabilities or the propriety of any particular level of taxation. The relief available to such a plaintiff consists entirely of the vindication of rights held in common by all citizens. It is thus scarcely surprising that few of the state courts that permit such suits require proof either that the challenged expenditure is consequential in amount or that it is likely to affect significantly the plaintiff's own tax bill. These courts have at least impliedly recognized that such allegations are surplusage, useful only to preserve the form of an obvious fiction. Nor are taxpayers' interest in the expenditure of public funds differentiated from those of general public by any special rights retained by them in their tax payments. The simple fact is that no such rights can sensibly be said to exist. Taxes are ordinarily levied by the United States without limitations of purpose. Absent such limitations, payments received by the Treasury in satisfaction of tax obligations lawfully created become part of the government's general funds. The United States holds its general funds, not as a stakeholder or trustee for those who have paid its imposts, but as surrogate for the population at large. Any rights of the taxpayer, which with respect to the purposes for which those funds are expended, are thus subsumed in and extinguished by common rights of all citizens. To categorize taxpayers' interest in such expenditures as proprietary or even personal either deprives those terms of all meaning or postulates for taxpayers a scintilla juris in funds that no longer are theirs. Surely, it is plain that the rights and interests of taxpayers who contest the constitutionality of public expenditures are markedly different than those of Hohenfeldian plaintiffs, including those taxpayer plaintiffs who would challenge the validity of their own tax liabilities. We must recognize that these non-Hohenfeldian plaintiffs complain, just as the petitioner in Frothingham sought to complain, not as taxpayers, but as private attorneys general. These are, and must be, to adopt Professor Jafe's useful phrase, public actions brought to vindicate public rights. It does not, however, follow that suits brought by non-Hohenfeldian plaintiffs are excluded by the case or controversy clause of the Article 3. This and other federal courts have repeatedly held that individual litigants acting as private attorneys general may have standing as representatives of the public interest. And there lists a bunch of cases. Shripps Howard Radio versus FCC, Sanders Radio Station, Associated Industries versus Ix, Reed versus Ewing, Scenic Hudson. Blah, blah. And then it goes on to say, as I understand it, the court's position is that it is unnecessary to decide in what circumstances public actions should be permitted, for it is possible to identify situations in which taxpayers who contest the constitutionality of federal expenditures assert personal rights and assert interests identical in principle to those asserted by Ophelian plaintiffs. This position, if supportable, would of course avoid many of the difficulties of this case. The court analysis consists principally of the observation that the requirements of the standing are met if the taxpayer has a requisite personal stake in the outcome of his suit. This does not, of course, resolve the standing problem. It merely restates it. The court implements this standard with the declaration that taxpayers will be deemed to have necessary personal interest if their suits satisfy two criteria. The difficulties with these criteria are many and severe, but it is not enough for the moment to emphasize that they are not in any sense a measurement of any plaintiff's interest in the outcome of any suit. It is surely clear that the plaintiff's interest in the outcome of a suit in which he challenges the constitutionality of a federal expenditure is not made greater or smaller by the unconnected fact that the expenditure is or is not incidental to an essential regulatory program. Presumably, the court does not believe that regulatory programs are necessarily less destructive of First Amendment rights, or that regulatory programs are necessarily less prodigal of public funds than are grants in aid, for both these general propositions are demonstrably false. Apparently, the court has repudiated the emphasis in Frothingham upon the amount of the plaintiff's tax bill, only to substitute an equally irrelevant emphasis upon the form of the challenged expenditure. The court's second criterion is similarly unrelated to its standard for the determination of standing. The intensity of the plaintiff's interest in a suit is not measured, even obliquely, by the fact that the constitutional provision under which he claims is, or is not, a specific limitation upon Congress's spending powers. Thus, among the claims in Frothingham was the assertion that Maternity Act deprived the petitioner of property without due process of law. The court has evidently concluded that this claim did not confer standing because the due process clause of the Fifth Amendment is not a specific limitation upon the spending powers. Disregarding for the moment the formidable obscurity of the court's categories, how can it be said that Mrs. Frothingham's interest in her suit were, as a consequence of her choice of a constitutional claim, necessarily less intense than those, for example, of the present appellants? I am quite unable to understand how, if a taxpayer believes that a given public expenditure is unconstitutional, and if he seeks to vindicate that belief in a federal court, his interest in a suit can be said necessarily to vary according to the constitutional provision under which he states his claim. The absence of any connection between the court standard for determination of standing and its criteria for the satisfaction of that standard is not merely a logical ellipsis. Instead, it follows quite relentlessly from the fact that, despite the court's apparent belief, the plaintiffs in this and similar suits are non-Hofieldian, and it is very nearly impossible to measure sensibly any differences in the intensities of their personal interest in the suits. The court has thus been compelled simply to postulate situations in which such taxpayer plaintiffs will be deemed to have the requisite personal stake and interest. The logical inadequacies of the court's criteria are thus a reflection of the deficiencies of its entire position. These deficiencies will, however, appear more plainly from an examination of the court's treatment of the Establishment Clause. Although the court does not altogether explain its position, the essence of its reasoning is evidently that a taxpayer's claim under the Establishment Clause is not merely one of ultra vires, but instead asserts an abridgment of individual religious liberty and a government infringement of individual rights protected by the Constitution. It must first be emphasized that this is apparently not founded upon any preferred position for the First Amendment, nor upon any asserted unavailability of other plaintiffs. The court's position is instead that because the Establishment Clause historical purposes, taxpayers retain rights under it quite different from those held by those under other constitutional provisions. I do not suggest that history is without relevance to use questions, or that the use of federal funds for religious purposes was not a form of establishment that many in the 18th century would have found objectionable. I say simply, given that ultimate obscurity of the Establishment Clause historical purposes, is it inappropriate for this court to draw fundamental distinctions among the several constitutional commands upon the supposed authority of isolated dicta extracted from the clause's complex history. In particular, I have not found, and the opinion of the court has not adduced, historical evidence that properly permits the court to distinguish, as it has here, among the Establishment Clause, the 10th Amendment, and the Due Process Clause of the 5th Amendment as limitations on Congress's taxing and spending powers. The court's position is equally precarious if it is assumed that its premise is that the Establishment Clause is in some uncertain fashion a more specific limitation upon Congress's powers than are the various other constitutional commands. It is obvious, first and only in some Pickwickian sense away of the provisions with which the court is concerned, specifically limitations upon spending, for they contain nothing that is expressly directed at the expenditure of public funds. The court has often emphasized that Congress's powers to spend are contrarious with the purposes for which and methods by which it may act, and that the various constitutional commands applicable to the central government, including those implicit both in the 10th Amendment and the General Welfare Clause, thus operate as limitations upon spending, and can attach no constitutional significance to the various degrees of specificity with which these limitations appear in the terms of history of the Constitution. Even if it is assumed that such distinctions may properly be drawn, it does not follow that federal taxpayers hold any personal constitutional right, such that they may each contest the validity under the Establishment Clause of all federal expenditures. The difficulty with which the court never comes to grips is that the taxpayers' suits under the Establishment Clause are not in these circumstances meaningfully different from other public actions. If this case involved a tax specifically designed for the support of religion, I would agree. Where no such tax is involved, a taxpayer's complaint can consist only of an allegation of the public funds have been, or shortly will be, expended for the purposes consistent with the Constitution. The taxpayer cannot ask for the return of any portion of the previous tax payments, cannot prevent the collection of any existing tax debt, and cannot demand an adjudication of the proprietary of any particular level of taxation. There is even reason to fear that unrestricted public action might well alter the allocation of authority among the three branches of the federal government. It is not, I submit, enough to say that the present members of the court would not seize these opportunities for abuse, for such actions would, even with our conscious abuse, go far toward final transformation of this court into a council of revision, which, despite Madison's support, was rejected by Constitutional Convention. I'm going to take a short break. You drink and take a bathroom break. All right. I'm going to restart that paragraph. There is every reason to fear that unrestricted public actions might well alter the allocation of authority among the three branches of federal government. It is not, I submit, enough to say that the present members of the court would not seize these opportunities for abuse, for such actions would, even without conscious abuse, go far toward the final transformation of this court into the Council of Revision, which, despite Madison's support, was rejected by the Constitutional Convention. We must, as judges, recall that, as Mr. Justice Holmes wisely observed, the other branches of the government are ultimately guardians of the liberty and welfare of the people in quite as great a degree as the courts. The powers of the federal judiciary will be adequate for the great burdens placed upon them only if they are employed prudently, with recognition of the strengths as well as the hazards that go with our kind of representative government. Presumably, the court recognizes at least certain of these hazards, else it would not have troubled to impose limitations upon the situations in which, and purposes for which, such suits may be brought. There is available a resolution of this problem that entirely satisfies the demands of the principles of separation of powers. This court has previously held that individual litigants have standing to represent the public interest, despite their lack of economic or other personal interests, if Congress has appropriately authorized such suits. See specifically Oklahoma versus Civil Services Commission. I would adhere to that principle. Any hazard to the proper allocation of authority among the three branches of government would be substantially diminished if public actions had been potentially authorized by Congress and the President. I appreciate that this court does not ordinarily await the mandate of other branches of the government, but it seems to me that the extraordinary character of public actions and of the mischievous, if not dangerous consequences they involve for the proper functioning of our constitutional system, and in particular of the federal courts, make such judicial forbearance the part of wisdom. The question here is not, despite the court's unarticulated premise, whether the religious clauses of the First Amendment are hereafter to be enforced by the federal courts. The issue is simply whether an additional category of plaintiffs, heretofore excluded from those courts, are to be permitted to maintain suits. The recent history of this court is replete with illustrations that questions involving the religious clauses will not, if taxpayers are prevented from contesting federal expenditures, be left unacknowledged, unresolved, and undecided. Notes and questions. Number 1. The first nexus. A. After Flast, does a federal taxpayer have standing to challenge the issuance of a commemorative Christmas postage stamp as violative of the Establishment Clause? C. POAU versus Watson. Assuming the issuance involves a substantial expenditure of federal tax funds, does it concern an exercise of congressional power under the Taxing and Spending Clause, or is it merely an incidental expenditure of tax funds in the administration of an essentially regulatory program? Why should this question be relevant to the taxpayer standing? Is it related to matters of justiciability? Consider Harvard Law Review. If a governmental regulation does violate the Establishment Clause, the taxpayer would sustain a special injury to conscience by the expenditure of the revenues under the regulatory scheme. Therefore, taxpayers could be designated as properly adverse Article 3 parties to sue to vindicate the public interest. But governmental regulatory action will usually encroach on the legally protected interests of a significant portion of the citizenry as well. Thus, there is no justification for concluding that the Establishment Clause itself should not be said to designate a special injury class of litigants as proper parties to challenge this category of governmental conduct. See also Hennigan, The Essence of Standing, the basis of the constitutional right to be heard. Does this state the court's intentions with regard to the first criterion? It is consistent with the court's footnote 17. B. The pocketbook injury requirement. On the likely assumption that if this particular stamp is not issued, some other one will be. Does this activity like that endormus not add any sum whatever to the cost of conducting the postal system? If so, is the establishment clause the establishment clause evil nonetheless present because the stamp issuance involves a substantial expenditure of tax funds, allegedly to favor one religion over another? In Dormius, may it be said that the Bible reading resulted in the public school being used to favor one religion over another, or to support religion in general, and thus the substantial expenditure of tax funds for general operation of the public schools was allegedly violative of the Establishment Clause. C. Stewart, standing to contest federal courts. Should there be taxpayer standing in both cases? Is the Dormius standard measurable disbursement of funds occasioned solely by the activities complained of in any way related to matters of justiciability? If the school authorities in Dormius had annually expended $100, $10 for the purchases of Bibles, would appellants have established the requisite special injury necessary to a taxpayer's case or controversy? Would there have been a greater assurance that the questions will be framed with the necessary specificity, that the issues will be contested, that the necessary adverseness, that the litigation will be pursued with the necessary vigor? Do these queries lead to a conclusion that in order to support taxpayer standing, the disbursement must be substantial rather than merely measurable, that this will assure a personal stake in an outcome of the controversy? If so, if the FLAS program involved annual expenditures to parochial schools of $250 million, does that support taxpayer standing? Even if one who pays federal taxes of thousands of dollars is hurt about 12 cents by the alleged illegality? Do the above queries lead to the conclusion that in all these cases taxpayers are non-Ophelians plaintiffs suing to vindicate public rights? Number 2, the second nexus. In FLAS's specific constitutional limitations criterion related to matters of justiciability, does the court effectively refute Justice Harlan's contention that in respect to the intensity of their personal interest in their suits, Mr. Frothingham and Mr. Flast are indistinguishable? Fundamental questions. Are Frothingham and Flast nonetheless distinguishable on the ground suggested by Justice Fortas, that alleged violations of the Establishment Clause, unlike alleged violations of the 10th Amendment, which concern allocation of power between state and federal governments, present issues of fundamental to our constitutional system, thus justifying taxpayer suits? Or consider Chief Justice Douglas's "The Bill of Rights is not enough"? It is possible to say that the First Amendment rights are by nature of the Constitution command so preferred that taxpayers should be given standing to protect them, and that the more vague, generalized rights of due process involved in other cases require that one who makes the challenge have a more specific, tangible interest at stake. What a constitutional right is, by the place of the framers, gave it in hierarchy a preferred right, standing to sue to vindicate it should be readily granted. Contrast Manning, the Douglas concept of God and government. While not only is there no evidence that its draftmen intended a preferment for the First Amendment, there is in addition nothing to support the theory that the jurisdiction section of the Constitution was to have a dual application. I should not think that cases and controversies can be given one meaning with respect to the final amendment, the First Amendment, another meaning with respect to the Fourth Amendment, and possibly yet another meaning with respect to guarantees which were embodied in the Constitution as it read before amendment. Do the views of Justice Mrs. Fortes and Douglas rest on the interpretation of Article 3 or on policy considerations. B. Substantive provisions involved. Does the vast majority rely on this fundamental notion? What of the court's position that Frothingham and Flast are distinguishable because the different substantive issues involved making Mrs. Flast, but not Mrs. Frothingham, an appropriate party to invoke federal judicial power, i.e., Mrs. Frothingham was attempting to assert the state's interest in their legislative prerogatives, whereas, as phrased by Justice Stewart, Mrs. Flast was asserting a personal constitutional right not to be taxed for the support of a religious institution. Does Justice Harlan effectively refute the position that the federal taxpayers hold a personal constitutional right under the Establishment Clause? See 57 ILBJ 236, 1968. If this right is not to have money collected from the individual by taxation expended for religion by government, its existence denied by the fact that a suit to enjoin expenditures cannot ask the return of any previous tax payments, cannot prevent the collection of any existing tax debt, and cannot demand any adjudication of the propriety of any particular level of taxation. Further, if this right is subject to a de minimis qualification and is only violated by substantial governmental expenditures, does it help resolve queries at the end of Note 1b supra? Does this discussion speak to the merits rather than to the standing? C. Other specific limitations on the taxing and spending power. Are there any? Suppose Congress appropriated funds for racially segregated facilities, for polygraphs to be used on all criminal defendants, for a federal censorship office, for subsidies to some newspapers, for the administration of general loyalty oaths to all public employees. They were calling it out back then. Hold up, what did this say? Other specific limitations on taxing and spending power. Are there any? Suppose Congress appropriated funds for racially segregated facilities, for polygraphs to be used on all criminal defendants, for a federal censorship office, for subsidies to some newspapers, for the administration of general loyalty oaths to all public employees. See Vogel versus Los Angeles. As assuming that all these activities are unconstitutional, whose rights do they violate? Taxpayers' rights? How about an appropriation of $50 to every member of the Republican Party? Of a large sum to be used for purely private and fraudulent ends? See Booth v. General Dynamics Court. May a taxpayer enjoin expenditures for nuclear testing on the ground that few interests are more specific than a taxpayer's interest in protecting his bones from disintegrating from the effect of strontium-90 introduced into the atmosphere during nuclear tests, and few limitations more specific than the Fifth Amendment's prohibition against deprivation of life? Carabas the Flast decision. Barrage or the breach of the dike. Breach in the dike. Are those constitutional provisions whose very language restricts congressional expenditures specific limitations? Consider University of Cincinnati Law Review, 1969. From Flast reasoning, the inference could be drawn that no other provision, even an express specific limitation on the taxing and spending power, could be viewed as specific for purposes of taxpayer standing unless it was included in the Constitution to prevent majoritarian abuse of that power. For example, the limitation in Article 2 prohibiting Congress from raising the president's salary during his term in office specifically limits the power of Congress to spend, but seems clearly to be directed toward preserving the doctrine of separation of powers, not toward preventing majoritarian abuse of the taxing and spending power. Likewise, the limitation in Article 1 prohibits Congress from appropriating funds for the support of an army for more than 2 years, is obviously designed to preserve civilian government by subordinating the military. State taxpayer suits. A. 3. State taxpayer suits. A. Are flash strictures on federal taxpayers standing also applicable to Supreme Court review of state taxpayer suits? Consider Sharp, Judicial Review and the Political Question, a functional analysis, 75, Yale Law Journal, 517, 521, and 12, 1966. In Frothingham, the court based its narrow interpretation of the case in controversy requirement upon an understanding of the federal allocation of functions to the three departments of government. The court's only legitimate function within that framework is to decide normal cases and controversies, and any expansion of that concept would change this balance. However, the federal constitution would seem to leave the states free to divide their functions of government differently and define the judicial power of their own courts somewhat more broadly than Article 3 of the federal constitution does. Thus, if a state permits its own courts to decide taxpayer suits, and if a federal question should be determined by a state court in such a suit, it seems that the separation of powers rationale should carry little or no weight for the Supreme Court's definition of what it is proper case or in controversy for purposes of appellate jurisdiction. In this situation, cases in controversy might well have a more permissive context, protecting only the functional requisites for the correctness of the court's constitutional decision, a well-developed case litigated by the best available possible parties. B. Are there other more particularized reasons for distinguishing between state and federal taxpayer suits? Consider note: taxpayer suits, Yale Law Review, Yale Law Journal, 895, 918 through 919, 1960. Because of the different nature of the bulk of federal expenditures, roughly 2/3 are devoted to the sensitive areas of defense and foreign affairs. Judicial review of federal action initiated in taxpayer suits is particularly inappropriate. In view of the greater need for legislative and executive discretion and flexibility in the fields of foreign affairs and defense, the initial frailties of the courts in reviewing construction, executive, and legislative action in these areas, and problems of discovery of necessary documentation and information. Finally, federal legislative and executive officials are more susceptible to the pressures of public exposure and criticism than many local and state officials, and official actions on the national level affect upon the party in power throughout the country, and therefore possess greater built-in protection against corruption and illegality. Compare Harvard Law Review, 1358. Objections to the granting of the standing to federal taxpayers have been the sensitive nature of many federal appropriations, especially those for the defense and foreign aid, and the fear of too many suits with attendant inconvenience in the daily affairs of government. However, the former objection can be met by denying standing as to expenditures in those spheres, and the fear of opening the floodgates of litigation may be minimized by making the taxpayer citizen pay the government's costs of litigation in case of frivolous constitutional claims. Standing of school children. In Dormius, would appellant have had standing if her child had not graduated? It is enough to say that school children are directly affected by public school practices. See School District versus Shemp. Or should attending be restricted to those school children and their parents who assert that their practices are contrary to their beliefs and offend their rights? Should any group interested in the operation and management of the public schools have standing? Does the answer depend on the scope of the public substantive constitutional right allegedly being violated? Consider Dixon, Religion, Schools, and the Open Society, J-Pub Law. Why should not the childless neighbor, as well as the parent, be deemed to have standing to question religious practices in the schools? Of course, the impact on a particular child is most direct concern to the parent of the child, and the interest of the childless neighbor would be directed more to a general social impact of the school practice in question. but it is not establishment clause separation principle, directed more to social impact than to personal impact. See also Black religion, standing, and the Supreme Court's role. J. Pub L. 459, 1964, for more detailed consideration. All right. And that, my friends, is the end of episode 4, or episode 3. Page 57. Thank you for listening.